Zachary Paul Cruz. Step up, sir. Are you Zachary Paul Cruz?
Yes.
Okay, sir. You are charged with trespass school grounds. Any objection to probable cause? Okay.
Judge, Mr. Cruz has made application to the public defender this morning. We have it. Obviously, it's up to the clerk to make a determination of indigence, but based upon the information that he's provided, we believe that he would qualify for the services of the public defender. However, Your Honor, we will be moving to withdraw and ask that regional conflict counsel be appointed. The reason being is that he may be listed as a witness in a homicide matter that we represent the defendant, Mr. Cruz. Judge, at this time, I'm going to ask Aura Tennis for the court to make a finding that he's indigent and would qualify, and then remove us from this case and appoint regional conflict counsel. I should let you know that before I came over here today, I did make a call over there to them to see if they could have an attorney present in the courtroom today. They told me that they didn't think that somebody necessarily, maybe they were perfect.
Sure, no, we have two representatives from regional counsel here.
Okay. All right, so you're making an Ori Tennis motion to withdraw?
I am, Your Honor, yes.
Okay, the court will grant that motion. So who is here on behalf of Regional Conflict Counsel?
Good afternoon, Judge. Joseph Kemak with Regional Conflict Counsel.
Okay, can you spell your last name for the record?
K-I-M-O-K.
Okay, so the court will appoint you on this case.
Yes, Judge. Judge, we reviewed the probable cause affidavit. We don't have an objection to probable cause.
Okay, so the court does find probable cause. State?
Judge Serenelle Murphy on behalf of the state. The state is putting forth an argument today, Judge, that there is probable cause not only under 810-097 for trespass on school grounds, but also within the same context of the body of the probable cause affidavit for trespass after warning under 810-09, the former being a second-degree misdemeanor and the latter raising this to a first-degree misdemeanor. We're asking that the court evaluate the proper bond criteria pursuant to 903-046, which, as the court knows, the first prong is to ensure appearance, and the second, and most important, is to protect the community. The first factor to be considered by this court is the nature and circumstances of this crime. It's the state's position, Judge, that weeks after his brother murdered, injured, and terrorized the school, he is there with no legitimate purpose in Broward County. After speaking with the arresting Deputy Butkowski, it was determined that after reading Miranda to him and talking with him on this particular day, he admitted this was not the first time he had been present on the school campus, but rather the third. The probable cause affidavit acknowledges that after his withdrawal from the school, he was told by the vice principal to stay away from the campus. As far as family ties, he has all the same flags present as his brother. His mother and father are deceased. His brother is incarcerated. When he was arrested, he gave a Parkland address where he does not reside. He is currently residing with his guardian in Lake Worth. When that guardian was contacted in reference to his presence in the city of Parkland and at Douglas High School, she was unaware. It is the state's understanding she is currently in the state of New York and has no idea how he got there or why he went. Therefore, he currently has no ties in Broward County. With regard to financial abilities, as we know, there is court proceedings pending to determine the inheritance of both Zachary and Nikolas Cruz at this time. The state is under the impression that he does have access to a $25,000 inheritance that passed immediately upon his mother's death. Addressing past and present conduct. In Broward County as a juvenile, in the year of 2016, he pled to 3 crimes, one of grand theft, one of criminal mischief, and one of petty theft. Since that time, as far as present contact, and probably most concerning, is his contact that he has had with his brother in the jail since his incarceration, where he has been heard and observed discussing how popular his brother is now, that his face is everywhere and his name is national. There is discussion of starting some sort of pen pal or fan club, and how many girls he is capable of attracting, referring to his brother Nikolas. We know that he was Baker-acted following the shooting. The nature and probability of the danger that his release poses and the nature and probability of intimidation and danger to these victims was demonstrated today in Broward County. When the parents became aware of his presence on campus, many kept their children home from school today. They have again been terrorized. The state is asking for a bond of $750,000 in this matter. We are asking that he be set on house arrest with a GPS monitor. He is to have no return to Broward County unless he is returning for a court date. He is not to return or be present on any school campus. We would ask that this court order that the home where he resides in Lake Worth be searched prior to his return to it for any guns, weapons, or ammunition of any kind. He is obviously not permitted to possess any gun, weapon, or ammunition in the pendency of this matter. He is to submit to a psychological evaluation and any follow-up that is deemed necessary to ensure the safety of the public. He is certainly to have no contact with any member of the Marjory Stoneman Douglas community. Stoneman Douglas students and all Broward students deserve to be protected. They have a right to go to school without fear. It's our position that this court should use every tool available to ensure that this happens. A simple Baker Act is no guarantee of that protection. As this court is well aware, within a matter of hours, he could be released back out with 0 terms and conditions to his release. So we're asking you to use all the tools in your arsenal, Judge, to protect this community.
Okay, defense?
Good afternoon again,
Good afternoon.
Your Honor. Judge, the state's request is entirely disproportionate to the crime with which Mr. Cruz has been accused at this point of committing. This is the standard bond of this is $25. Mr. Cruz, according to the Sheriff Daughter website, posted that bond. He should have already been released. He is being held because of who he is related to, not because of anything that he did. All of the requests that the state just made are trying to punish Mr. Cruz for who he's related to, not for skateboarding through the school grounds. Mr. Cruz, it's well documented, lost his mother recently. He has lost his brother in an unimaginable way. Now, for the state to request a $750,000 bond with all of the conditions that they are requesting is simply a reflection of their punishment for who he's related to. We would ask that the court maintain that $25 bond. He's already posted it. He does not have any there were no adult misdemeanors even or felonies that the state listed off. To say somehow that Mr. Cruz is a danger to the community based on nothing other than what's in this probable cause affidavit is simply a fallacy. There's no indication of violence from Mr. Cruz. There's just nothing, and the state is seeking to make a show of this. And we would ask the court, there was a $25 bond posted. That's what it would be for any other person. That's what it should be for Mr. Cruz.
Okay, anything else?
No, Your Honor.
Okay, this is what the court's going to do. Court finds, based on the totality of the circumstances, the court is going to put an ankle monitor on him, GPS level 1. Court notes that he is the brother of the alleged shooter at this school. He is not a student at any Broward County school, in particular Marjory Stoneman Douglas. He resides in Palm Beach County. He has no legitimate business at the school, and he came onto this campus after being warned. Therefore, for the safety of the students and the community, and the court has concern that we just had a major tragedy, the court is also going to order that he maintain 1 mile from Marjory Stoneman Douglas School at all times, that he not have any contact with his brother, direct or indirect, that he not go onto any campus of any school or child care facility, and he maintain 500 feet at all times. In addition, he is to have his home in Lake Worth searched for guns, ammunition, and any weapons. He is not to return to Broward County unless it's for a counsel, and he's advised pretrial services or to attend court. The court is going to set his bond at $500,000. Thank you.
Judge, we will object to the amount of bond for the reasons previously stated.
Okay, and one other thing I forgot, I'm sorry. He's to submit to a psychological evaluation, and he's to have no contact with any Marjory Stoneman Douglas campus or any students or teachers or employees of the school. Is there anything else, State? Okay, thank you very much.